Kristi Dosh, someone we have had, columnist for Forbes, writes for Sports Business and much more, joins us on 365 Sports with Craig Smoke. I'm David Smoke. And Kristi, thank you so much for your time. By the way, congratulations. What? You have a new niece, is that correct?
I do have a brand new, I guess she's now 4-day-old niece.
That's awesome. Yeah, the thrill of that. Thank you for your time. So, breaking down the House settlement for back pay and revenue sharing, you wrote a lengthy article on it a couple of days ago. Let me ask you about a couple of things first. There was this flare-up over the weekend of reporting and people kind of going home that there was a section about boosters who did anything above $600 would have to get cross-checked by, I don't know who it would be. Is that going to affect any boosters involved with NIL, or is that just making sure that there are no straight cash payments?
So the way I read it, there's two sections people are kind of mashing together here. I think there's one on mandatory reporting, and it's saying that any NIL deal you do of $600 or more, you're going to have to report to some entity. We don't even know what that entity is yet. However, that section doesn't say anything about approving or disapproving deals or vetting them, just that you're straight up reporting it. And it's getting a little bit confused by a later section. This is a 133-page document, so there's a lot there. And there is a later section that says the NCAA may, it doesn't say they have to, it says they may adopt rules that look at deals in terms of fair market value. And it also talks about it being for products and services that are for profit. That section people thought was aimed at some of these NIL collectives that are 501c3 charitable organizations. But that provision is not a mandatory part of the settlement. It may never come to pass. So what we have right now is just mandatory reporting of 600 or more. But the way I read it, there's no vetting of those deals. It's just for informational purposes only.
Kristi Dosh with us on 365 Sports. So in the end, the back pay, that goes back to, we've seen the timeline. How much of the percentage of the money, the 2 billion minus attorney fees, will most of that, or 75 or so percent of that, be the football players and men's basketball players?
Yeah, there's a pretty big percentage of that. They're saying football and men's basketball players on average are going to get about $135,000 each. Women's basketball, about $35,000 each. And then there will be some sort of, I would call them nominal amounts given to Division I athletes in other sports. There's going to be a formula that decides that for each individual athlete. So you'll see it really varying from one school to the next and even from one player to the next.
Now, the scholarships being moved from 85 to 105 and more, who does that affect the most, as far as in your opinion, and maybe who gets hurt the most if that's the case?
You know, I think you see most of the Power Five going to the 105 for football. I don't think that will surprise anyone to hear. That also means you probably got to make some changes on the women's side because of Title IX. And so a lot of the emails I've gotten have been from parents of female athletes who are all excited because they've seen the roster limit for, say, women's soccer or volleyball be increased, and they think now their daughter is going to get a full scholarship. And I don't think that's necessarily the case. It's going to vary from school to school. They're going to have to make some changes on the women's side to offset what they do on the men's side. But we're not talking about every athlete on every roster going to full scholarship, although that's allowed now. I don't think most schools are going to have the funds to do that and also engage in revenue sharing.
So you mentioned football, men's basketball, and also women's basketball. Moving forward with the revenue sharing, is it going to be pretty much that same percentage moving forward within that particular way?
I have talked to so many schools, and again, it varies so much from school to school. Some have said that their plans are to look at what percentage of their revenue comes from football versus what comes from men's basketball, women's basketball, break it down by sport and then share revenue proportionately according to what share that sport generates. The problem is Title IX attorneys are saying that's not going to work, that's not going to comply with Title IX. And instead, they're suggesting you have to be equitable in the sense that if you decide to revenue share with, say, say 150 male athletes. You need to also do it with 150 female athletes, but most of them are conceding the amounts won't have to be the same, that they should be based on some sort of fair market calculation. But every single school is going to do this different, and they probably should, because if they all decide to do it the same, they could end up in the middle of another lawsuit accusing them of collusion.
Can you see all of what has been the buildup of this with what Jeffrey Kessler has said, among others? Can you see this being like locked in and moving forward, or is this still going to be delayed more and more as they tweak what's in the settlement?
Most settlements go pretty smoothly from this point, but I don't expect this one to. There's already been some opposition from Division I schools who felt like they weren't part of this conversation. There's already athletes coming out upset about it. There are agents and attorneys and collectives who are upset about it. So I would expect that when the court goes into the phase where they allow people to voice their opposition, there's going to be quite a bit of that. And it'll be interesting to see what Judge Wilkin does with that, and if she wants tweaks to the settlement or if she goes ahead and processes it as it is right now. We won't really know that probably till early 2025 at this point.
With the revenue sharing, we know there's NIL, and that's separate, correct? Than the revenue sharing, that's going to be a separate money fund to the, or I don't know if I should say it that way, but money pipeline to the players?
Absolutely. So the revenue sharing is essentially going to be capped. We believe that cap for the first year is going to be somewhere between $21 and $22 million. But that doesn't count any NIL money that's being generated, whether that's a collective that's helping athletes get deals, athletes getting them on their own, or an interesting part of this settlement is that athletic departments can now serve as agents for the athletes, or exclusively or non-exclusively. So the athletic department can go out and source deals for these athletes now. And all of that would be in addition to revenue sharing. And there's no limit on the amounts for NIL.
So we're working on an NIL possibility with what we do on game days for Baylor after their game's over with a post-game show, and discussing an NIL possibility with a player in the post-game. Does, with what we now see, and we're using the GXG, which is heavily involved now with Baylor and has been, made a difference for them. Do they stay, like, are they now under the umbrella of the athletic department? How does that work?
So each individual athlete will get to make the decision about whether they want to sign an agreement with the athletic department. And I would imagine there will be some athletic departments that decide not to do this at all. They don't have the staff, they don't have the bandwidth, or maybe they don't want the legal liability of representing student athletes, but they're going to have that choice. And then the athlete could choose if they want to be represented, and it can be on an exclusive basis or non-exclusive. I would be surprised to see many of those exclusive deals where you're saying, okay, only the athletic department is going to represent me for NIL. Frankly, I don't think that makes sense for student athletes, and I don't expect to see much of that.
The revenue sharing of what an athlete gets for being on scholarship, for example, cost of attendance, value, new scholarships, does that fall under the revenue sharing, or is that separate?
Parts of it are going to. So they laid out in the agreement that things like the Alston Award and other benefits that are offered sort of above and beyond that full grant and aid, in addition to the new scholarships being created because of new roster limits, there is going to be some of that that's going to be counted towards revenue sharing. So it's a max of $2.5 million in Alston Awards that can be counted, and $2.5 million in additional scholarships that can be counted against that revenue share.
Will this be an individual school-by-school decision, or will conferences take their schools under their own, I guess you could say, wing, and have the conference decide how things go?
I'm doing some consulting work with a few schools and who engaged us months ago, and we've been talking about what this might ultimately look like, and no one is expecting the conference to set those rules. I think that's inviting lawsuits related to collusion, and I think every school's resources and abilities look a little bit different. So right now, everyone I know is proceeding as if it's going to be done on a school-by-school basis.
There's a reason we have you on, because of how you explain things. So I did see, and I mentioned this, earlier in our interview, that when the booster information came up and $600 was that number, I believe it was Livy Dunn's mother who went on Twitter and said something about if they're going to do that, then they need to go to every student at every college campus who makes anything more than $600 and make them report that too. Is that a complicated issue?
Yeah, I teach NIL classes at University of Florida, and I get cheerleaders and dance team members and just regular students on campus who take my NIL class because they have large followings on social media and they're doing brand deals themselves. And they, figure they can learn the same sorts of things the athletes are learning how to do. And they don't have anyone looking over their shoulder or making them file about what sort of deals they're doing. So it is a bit of a double standard. And I understand that it exists because you probably don't have the same situation, with maybe just an average student on campus who happens to have a big social following. You don't have a booster who's trying to entice that person to go to school there. What do they care who's going there and majoring in English or journalism or whatever? And so you don't have the same influence you get in athletics. So I get what they're trying to do, but I also understand Libby Dunn's mother being upset about it and what she's saying because it's not fair. It's only being done to athletes.
Will the revenue sharing be available to student athletes more than 4 years, since that's the normal average? Although now we put up a list earlier in our show, there's like 8 guys that have been in the college football for 8 or 9 years. Will it be capped, and is that going to be an issue in court?
So that's in the section that I was talking about earlier, where it talked about some rules that the NCAA may make, not that they have to make. And one of those is to say that you can only have revenue sharing for 4 years of eligibility, and those years have to be in 5 consecutive calendar years. So that's not officially a rule and won't become a rule just because of the settlement. The NCAA would have to separately pass that. That's one of those I could see them passing. So we'll have to wait and see on that one.
Kristi, when a player gets NIL, and we've seen this before, and I think there's an article even a couple of weeks ago, and I can't remember exactly where I remembered reading it, but I brought it up. And you get right in the middle of all this. If somebody signs an NIL deal, wherever they go, whatever sport, let's just say football, and they get themselves sideways with the law, or they decide to leave, how does all that work out in making sure either somebody's reimbursed or that the athlete fulfills their obligation?
Yeah, each individual contract handles that a little bit differently. I've seen ones that try to restrict the athlete to living in, say, a certain county, and that's so that if they transfer, they won't be able to complete the terms of their contract and they won't receive the rest of their payment, because the NCAA has said that these payments can't be dependent on you being on a roster. They're not supposed to be based on whether you play or not or whose team that you're on. And so collectives and brands have gotten creative about what they've put in their contracts for this. It is pretty common to see the morals clause like we see in a lot of pro contracts, where if you are, say, arrested on a DUI, a brand or a collective would have the ability to cancel the contract and not make any future payments to you. But what I think is going to be really interesting going forward with the revenue sharing, and we're already seeing this with some collective NIL deals, is going to be what we call clawback provisions, where say they've already made certain revenue sharing payments to you, and then you decide to transfer, that they can actually essentially claw that back, that you can have to pay that back. Or it might look more like what we see with coaches, where the school you're going to has to pay to get you out of the contract at the last school. So it'll be interesting to see how everybody decides to structure those contracts.
So when college coaches leave, there's a buyout. For example,
right.
let's say it's a coach that signed a 5-year, $45 million deal, whatever it is. If they leave a year or two or whatever early, they have to pay a buyout. Will that happen with the student athlete?
I have heard athletics directors say that they intend to put those provisions in their contracts. Now, when I tweeted about that, there were several agents and attorneys who responded to me immediately to say they would never allow their client to sign that. So we'll see where that's headed. But I do know that schools are actively looking into what their contract is going to look like and wanting to include provisions like that. So I would imagine they're going to end up at some schools, maybe not everywhere, but I bet somebody's going to try it out.
All right. What about the possibility? We hear about employment, that the student athletes will become employers, collective bargaining. Does what you saw in any way change whatever momentum or lack of it might happen?
There is a provision in the House settlement that talks about what happens if athletes, some of them or all of them, become employees and collectively bargain. And it essentially says if they're able to do that, and they come to an agreement that's better than this one, or if they want to incorporate this one into it, that's all well and good. But I would say that if they were collectively bargaining and the agreement was not going to get them the protections and the money they're getting under this, then the attorneys in this case are going to have a problem with it. So for the next 10 years, I would say this settlement's going to exist in some format, either on its own or eventually being incorporated into a collective bargaining agreement.
All right, so correct me if I'm wrong, but there was, when I saw this settlement as it started to pick up steam, that I even saw some things written about this will keep any more lawsuits from happening when it comes to the NCAA. That's not true, is it?
That's unfortunately not true at all. In fact, there's still multiple cases. I have an entire page on my website where I try to keep up with all of the open cases. Now, 2 cases got consolidated into this one. The Hubbard and the Carter cases are part of this settlement. So those 2 are wiped out. But there are a number of other cases out there about NIL, about employment, about antitrust law that are still open and pending and are still issues for the NCAA. And not only are those still open, but attorneys that have already read this settlement are already talking about all the different kinds of lawsuits that can come out of this settlement and some of the choices they made that athletes had no ability to weigh in on. So I would expect not only do we have those outstanding cases, but there's probably going to be some new ones as well.
Let's say a school has 15 or 25 sports, and I know endowments take care of it, like Stanford has an endowment, and a lot of schools do, that might take care of some of the scholarships and athletes. Is every student athlete on scholarship guaranteed at least a penny when it comes to revenue sharing?
No, absolutely not. I would expect that there will be large numbers of student athletes who get nothing because schools, I don't think, are going to be able to afford to give everybody something across the board, at least not and maintain their current level of sports sponsorship. So absolutely, I think we'll see sports being cut at some schools. And, you know, like I said before, a lot of the parents who are reaching out to me are parents of Olympic sport athletes who are trying to figure out, is their kid going to have a full scholarship now? Because now everyone on the roster can have a full scholarship. And they're really disappointed when I tell them no, that it may be that nothing changes. It may be that they get even less than they are currently getting. It really is going to vary a lot from one school to the next. And when you're being recruited, you know, you're going to want promises that take you through more than just 1 year, because the budget could get adjusted every year and you could find yourself in a really different situation from 1 year to the next. So, you know, one thing that worries me about all of this is the level of education that's going to be required for parents to help their high school student athletes navigate this during the recruiting process. And especially right now, if you've got a kid that's going to be starting fall of 2025 and they're going through recruitment right now, the schools don't have any answers for you. So you're making a choice on where to attend based on limited information, because the schools are still finding out what this is going to look like. They're still getting advice from their Title IX attorneys. They're not going to know what kind of compensation packages they're going to be offering, but you're going to have to make a decision before that information is probably settled. So I think in particular, folks who are starting fall of 2025 are going to be in a tough spot. But we've got the transfer rules now that allow you to more freely transfer. So I would imagine that the transfer portal will remain very active going forward.
130-something schools in the FBS, 350 plus when it comes to the NCAA, when it comes to the men's basketball programs that compete for the tournament or try to get to the tournament. How many of those, and I guess a percentage, this is bad news?
You know, I would say if you're outside of the Power Five, it's probably bad news. I've talked to a number of athletic directors and commissioners from the Group of Five, and then also from non-Division One football playing schools, non-football schools who are Division One. And they're saying that they really didn't get to have any say-so in what this ultimately looked like, because only the Power Five conferences were parties in this case. And so they were the only ones who were kept abreast of what was going on during the course of the settlement talks. And now everyone in Division One is going to have their distributions from the NCAA docked in order to pay for this back pay that's part of the settlement. And so you've got schools who are going to pay for part of this settlement, and it's not going to be any of their former players who are actually getting the money. It's going to be largely players at Power Fives that are getting the money. So I would say any institution or athlete who's not in the Power Five, this settlement's probably not great for them.
Why would a student athlete opt out of the settlement?
if you opt out of the settlement, you're preserving your right to bring your own case or be potentially part of another case. And so if you feel like this doesn't adequately solve problems you individually have, maybe you could have made a lot on your NIL prior to the NIL rules changing, or, perhaps you're a football player with a big household name and you feel like you could have done better on this. I mean, I think there are some circumstances where it makes sense to opt out. I don't know how many of those opt-outs we'll have. It's one of those things people are still getting educated on. And unless you have an agent or an attorney or somebody in your family who's one, I'm not sure where you'd be getting the advice on this. So I don't expect a ton of opt-outs, but there will probably be a handful.
How do your students in your NIL class at the University of Florida, how do they digest all of this? Is it something that it's like they can't wait to get more information, or are they sometimes confused too?
I feel bad for my summer school students. I'm teaching 2 different classes, an undergrad and a grad class this summer. This is their last week of classes. Exams begin into this week, beginning of next week. And I had to send them an email Friday saying, guess what? We have a new settlement. But I'm trying to limit what I'm actually testing them on. I told them, look, I want you to be aware of this, especially my grad students. A lot of them work in athletic departments. And so I sent them that article I wrote breaking down the settlement. And I said, I want you to know this, but I'm not going to test you on it, because I don't expect them to upend everything they've learned all semester based on this new information and be tested on it 5 days later. That doesn't seem fair to me. But for my students next semester, we will definitely have a lot more of this.
I know you got to go, but another question or two. Of the schools or athletic departments or parents of student athletes or agents or whatever, which of those particular segments of people contact you for more information or consulting work?
It's a toss-up between schools and parents. I mean, I've done consulting work for nearly a decade with schools. And so, a lot of those folks already know me and I've done work with them in the past. The parents is a new one for me. I had never really heard from a parent until NIL happened in 2021. Now I run a whole Facebook group of almost 1,000 parents where they can ask me questions about NIL and now revenue sharing. And so I've been a little more in that parenting space lately. And I get probably 25, 30 emails a week from parents asking about NIL. And now with this revenue sharing, I've probably gotten 20 to 30 in the last 48 hours asking, my daughter's a sophomore. She plays soccer at this school. Is she going to get a full scholarship next year? And important to note, none of this goes into effect for the 2024-2025 school year, because this settlement can't even be approved until early 2025. So all these changes people are hearing about, they're for the 2025 school year. So we're not even quite there yet. And unfortunately, I would say the people who can be excited about this are football, men's basketball players, and women's basketball players at Power Fives. Outside of that, I'm not saying it's bad, but that's who can be excited about it.
You founded your business, Sports Business Enterprises, in 2012. Can you fathom in the last 12 plus years what you have seen yourself when it comes to just college athletics and how business has changed?
I was practicing law full time when I started Business of College Sports and started writing for Forbes, and the Ed O'Bannon case was happening. And I remember saying that this was never going to happen. They were never going to be employees. Mm-hmm. They were never going to do revenue sharing. And I really believed it at that time. And obviously it's happened now, and I embraced it a long time ago and knew it was coming. But, that's a big change over the past decade or so, from athletes essentially having nothing but their scholarship to, we went to unlimited meals, and then we went to cost of attendance, and then Alston Awards, and then NIL, and now revenue sharing. That's a lot of change in a decade.
And they finally got the video game back about that same amount of time from when you first started. You're doing a great job, Kristi. It's great to have you on the show. Thanks for the knowledge and insight. We appreciate you a lot.
Absolutely. Thanks for having me.
Kristi Dosh. You can go to Kristi Dosh, KristiDosh.com. Again, she found